Alex here with part 197 of the My Docket series on child custody and visitation. As in my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are: number one, not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We finally get an order on my son's need to go see an optometrist. If I remember correctly, the order still sucks because it requires me to go to Reno, which is insane given it's 300 miles away. And so I end up filing another motion to get permission. I think it's actually to get sole legal custody. And then that motion is the good one that takes care of the rest of these problems. But it's still an order. My mindset at the time was mixed. On the one hand, it was nice to get an order granting without all of the stress of a hearing and all of the nonsense of my ex's attorney putting whatever he can come up with in an opposition to get his way, regardless of what's best for the children. Number two, the sort of other side of that coin is the whole you have to go to Reno type of thing. So it's still annoying. It still doesn't solve any problems. It still perpetuates the litigation, which I've talked about before, how family court judges complain about having too much work, and yet by their own orders they create themselves more work. So that's what's happening here. This order is just going to lead to another motion, which is just going to lead to another order, and then that's the order that finally solves the problem. So I don't know what else to tell you guys. It's like the Twilight Zone. Anyway, let's go ahead and go straight into what the judge has filed. Here we have the order granting motion seeking leave of the court to set vision appointment. The court has reviewed all papers and orders associated with my motion seeking leave of the court to set vision appointments. It now finds and orders as follows. So this is the same old spiel. Findings of fact that are being made by the court without an evidentiary hearing, but most of it is just going over the procedural history of the case, so most of it is harmless. She does sometimes slip in a finding towards the end of the document, which is not proper, but it's fine, I guess, especially since it's not adverse to me. Anyway, in this case, we have a common minor child. You guys already know this. I'm seeking leave of the court to set the vision appointment. I'm alleging I don't know when my ex plans to schedule the appointment due to her failure to communicate. I'm alleging that she has a very negative history concerning the child's medical needs, and that I request the court distinguish whether I have leave to set the appointment just once or if the parenting plan is permanently modified. Conclusions of law. District Court Rule 13 allows the court to construe a lack of an opposition as an admission on my ex's part that my motion is meritorious and should be granted. She cites the date that I served my motion upon my ex, and she mentions the fact that my ex has failed to file an opposition. Given the evidence of my ex's failure and or refusal to communicate in a reasonable way regarding our child and his health needs, I am granted leave to set a vision appointment. I shall schedule a vision examination with our minor child's vision provider, Terrence Cochran. Due to my ex's failure and or refusal to administer the minor child's medical needs, I shall make all future arrangements for the minor child's regular vision appointments in Reno, Nevada. However, as the parties are joint legal custodians, I'm not permitted to change the minor child's vision provider without consulting with my ex, who doesn't respond to any emails, and reaching an agreement regarding the same. I shall have the sole right to attend vision appointments with the minor child. So I end up doing nothing with this. It's like, yeah, okay, thanks. I'm going to file another motion. That's what I'm going to do. So, I mean, it's nice that she ordered this, but I can't do anything with it. So I'm not going to fly 300 miles to schedule a vision appointment. It's absolutely ridiculous. You know, it pisses me off because she complained about Judge Weller saying midnight exchanges, blah, 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 and how obviously that's wrong. No parent in their right mind is going to schedule a vision appointment 300 miles from where they live. Like, this order, I just don't understand where I don't understand what they're doing. Guys, I try as hard as I can to figure out what they're thinking when they say these things, and I can't even give you an explanation sometimes. It's just so insane. Anyway, the next motion, I know I've said it like 5 times. I'm just gonna file another motion. That motion will get granted, and then I'll be able to take care of this problem. So I filed one motion seeking leave of the court to set the appointment. The court has disposed of that motion by granting it. Going into the aftermath, I filed nothing, so I incurred $0 in costs. My ex filed nothing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees, and my ex didn't have an attorney either, so she incurred $0 in attorney fees as well. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.